A very good evening to you and welcome to Powerbrief. This being the 18th day of the month of March, the year 2021. We've had a long day looking into the Machakos senatorial by-election, and our guests have been here since morning trying to dissect into a number of matters that affects a general election and also a by-election. And tonight we take a break from a real politicking and taking another angle of just doing an educative piece on Powerbrief, especially on matters legal. When you wake up in the morning, especially at this time when we're having the COVID-19 pandemic, you realize that you'll have to put on your mask. But someone else asks themselves, why should I put on a mask? If Corona catches me, then it is me and me alone. But still, the law will catch up with you. And tonight, we are privileged to have two advocates of the High Court of Kenya, that is Hadassa Rimunya and also Caroline Deritu. Together, they'll take us through this program just to understand some of the crucial matters that you need to understand about the law, how to relate with yourself, how to relate with others, and how to adhere to what the law has to tell you. My name is Cornelius Omuse and I welcome you to join us in this conversation. You can also engage us on our social media handles. Facebook is CAC TV Kenya, YouTube is CAC TV Kenya, and our SMS number is 22167. Ladies, welcome to Powerbrief tonight. These are special for you. Hadassa, it is your first time to be here.
Thank you, Cornelius. Thank you for having me.
Karibu sana. And before we get to the business, I don't know of the day or of the night, in the morning or sometime yesterday, we got sad news that one of the heads of states in East Africa, that is John Pombe Magufuli, has passed on. And in that regard, condolences are keeping on coming in from different leaders, but also you are leaders at your own capacity and more so people within East African region. So it is African, it is also human that once someone has passed on, just to have that time to console the bereaved. I begin with you, Caroline, just to have a word with the family, friends, and also the great people of the Republic of Tanzania.
Thank you, Cornelius, and I'm happy to be back here again. So I would wish to send a message of condolences to the people of Tanzania. I know losing such a leader is quite a loss to the people of Tanzania. We have known President Magufuli in his own ways and in the ways that he tried to assist that country. He was also of course, we knew him as a wise man of many words, and more so in terms of his culture. So we would wish to send out our condolences to the people of Tanzania and also to his family. So it's a sad day for Tanzania, and I wish for them to understand that we are together in this.
Thank you very much, Wakili. Let's also hear from Hadassa. Your name sounds like it comes from that side, but anyway, just say a word also to...
Yes. I want to associate myself with the sentiments of my colleague and also pass my condolences to our brothers. As you said, my name might be from there. We have interacted so much. They are our brothers, our uncles. We have intermarried. So inadvertently, we share their pain. The late... President Magufuli was a very astute politician. He was a very sound man, so to speak. So it's a loss not to just the Republic of Tanzania and to Tanzanians, but also for the region as a whole and to the continent as a whole. So we pass our condolences and we hope for the best, even as we look up to the succession.
Thank you so much, Caroline and Hadassa, on that. And tonight we will wish to do an educative piece on this thing called law. And just as I was doing the introduction, there's something I was mentioning. Just as Carol was coming in, alisema kwamba alikuwa amesahau mask. I know apart from actually taking care of herself not to get COVID, she's also fighting so hard not to be on the wrong hands of the law. as it's actually a requirement that you need to have a mask, you need to observe social distance while in vehicles, do ABCD just to see that you prevent this coronavirus. And as you ask someone, atakwambia ni sheria imesema hivyo.
Yes.
And someone at times wonders now, what is this sharia? Why do we need it? But before we get into that and understanding some of those issues from your background and also what you've studied, we really wish to know the sources of the law. Where did this thing called the law come from? Because sometimes inasumbuanga watu sana. Where did we get this thing called the law?
So the law.
Yeah, the sources of the law.
Yeah, you'd originally, we talk of the law being man-made. So even in our traditions, or even during the caveman period, man sat down and thought probably there was some disorder, some disorganization within the community. So there's various theories of people who came up with the law. But generally, the law has been set by man, and it is there to provide guidance and assistance, more so to the relationship between people, or perhaps people and objects. So mainly, the law has come from man. There's the law that God has made, and we know that, and that is in the Bible, the 10 Commandments. But when we talk about the law that governs us, the law that is in the statutes, the law that is in court, the law that governs our daily activities, that has been made by man. And perhaps we were not there, or we might not be able to really go back in history and understand at what exact time man decided to sit down and give some, prepare the law. But as we understand even from school, I think this generally originated from the Romans. So I think we are guided by that, being that the law that we have is a man-made law. Yes.
Thank you. Now, from your part, Hadassah, looking from what Nerito has just spoken about, some time back we had another lawyer here who was actually trying to explain why we have the law and why man commits crime. And one of his explanations was that nature is cruel. And nature being cruel, it makes man most of the times to run away from nature. And in the process of running away from nature, the same man inflict pain on a nearby man. For instance, you're in trouble.
Yes.
And when you're trying to run away from trouble and Carol is within, and there is a way you can inflict pain on her so that you avoid pain, you will gladly do it. Does it mean that why we have the law is because of man's nature, human beings' nature of doing wrong at any time when they find an opportunity to do that?
That is true. Human beings, we are intrinsically selfish. If we look at back to where creation, the story of creation, yeah, we are of a fallen nature. That is there. But what happened is we were living in a system of a jungle system, man eat man society. What is best for you is what you will do. So people came together, and that is what you're alluding to and what my colleague is also alluding to. People came together and decided we cannot continue like this. For the future of humanity, we need to have some sort of order. And that's where the social contract came into place, where we decided we'll come up with systems and laws which protect us against ourselves, and also will give this authority to a certain person who will be able to now govern us in terms of implementing what we have decided, in terms of making sure that the systems run as they do. And you can see this reflected in our constitution, because the constitution, the preamble says it is by the people for the people, meaning it is us. We decided this is what the rules, these are the rules we want to govern us, and these are the people we have elected to make sure that we stay within these rules or within these boundaries. So yes, to answer your question, we are intrinsically selfish. If I am to gain at the expense of my colleague, chances are I will.
And the same case if Carol is to gain at your expense,
chances are
that, though we are not saying that that's what will happen as we get out of this room.
In the jungle society, those are the rules of the game.
Thank you. Now, there is something here that when she talked of the common law, the statutes and the laws that are made in parliament, all these, when you look at it, these are modern laws that came about when we were colonized. The colonialists came, and then in the same process, hiyo ndio sababu mkaanza kuvaa hizo wigs and everything, which a number of people are trying to fight that we should not be putting it on. We had the African laws. I'm told they have been there since those day before even the colonialists came. The Kiama, those ones that are found in the central area. When you go to Western, when you go to Luo, when you go to Coast, wazee wa Kaya, wamekuwa pale since very long time ago. They had laws guiding their people on how to relate. When you're in a marriage, how do you behave with your wife? How do you behave with your husband? When it comes to time of divorce, what are these grounds that makes you people to divorce? When you you've killed, what happens to you? The community excommunicates you, or sometimes maybe you're stoned to death. So we want to look at the differences, whether this modern law came to change anything, or did it interfere with what we used to have as African law? Did it come with something different? Did it come and say when you kill it's right? How did it come about?
The modern law, or rather what you wish to call now the modern law.
The one you practice, you and Adasa, which keeps on affecting me on a daily basis.
We still practice the cultural laws or the traditional laws. You see, even with the fact that we adopted some of the English laws, you know, as we understand, we were colonized by the British. So the British also came with their laws that used to govern them in their country, which came to be adopted by the Kenyan. By Kenya. So it doesn't mean that the fact that they brought in the common law, or rather what we understand as the laws which were adopted from England into Kenya, the traditional way of dealing with issues ceased in Kenya. You see, I'll also refer back to the constitution. You know, as much as we have the statutes, we have the precedents which come from court. We also have the traditional law, cultural laws that have been brought about by cultural practices in Kenya. So much that the traditions that govern any particular community, as you understand, even traditional marriages are recognized within the society and within the law. So if you're from Maasai, the Maasai community, and from the Kikuyu community, someone else is from the Luo community, if someone is married within those particular lines of the laws that govern that particular community, when you look at the divorce proceedings, the same laws will apply. You know, when we want to understand whether you are legally married to this person under the Kikuyu customary law or the Luo customary law, we'll wish to delve into that law with people who understand that law better and see whether the requirements of that particular law had been fulfilled. So the fact that we have the modern law doesn't mean that the traditional laws have been done away with. The only thing that comes into mind is that if those laws are draconian, they are punitive or they are oppressive, and they go against the law which has already been set by the supreme law of the land, which is the constitution, then we cannot abide by those laws. We have to look for other sources of law which will practically merge with the constitution so that we can practice that.
Thank you, Carol. Now this takes me back to Hadassah, and you mentioned something very important here where I was almost coming there, but you read my mind very fast. Some of these punitive laws that she has just mentioned, unapata watu wanakaa chini wanasema hii kitu like the FGM mababu zetu walikuwa wakifanya.
Yes.
And in our culture, a woman sio mwanadamu. Mwanamke anafaa kukatwa masikio, anafaa kutobolewa hapa to show that she is able to sustain difficult circumstances and even run a home. Mababu zetu walifanya, kwa hivyo hii sheria ya nchi sisi hatuitambui. What has been the approaches by the common law? has it been in a way like the way wakili has just to tried to explain ya kwamba hii ni mbaya, kwa hivyo tujaribu kuembrace, or the government or the common law has been using force to enforce the new laws?
That's a good question. You know, the law does not operate in a vacuum. There has to be a philosophy behind it. There has to be a reasoning behind it. There has to be a reason why you decided to do this way, to make this a right and make this a wrong. There are some laws that were right before, but now are wrong because the people keep progressing. Cultures keep progressing. We keep evolving as human beings. And as we evolve, those cultures also need to evolve to reflect the times. So yes, there are some laws that would be culturally punitive. And as she has mentioned, what supersedes is what we have agreed collectively. Because if we come and say we are going to enforce all 47 cultures, we will not have the homogeneity and the unity that binds our people within the borders of Kenya. So we need to have a law that supersedes all the different little cultures to come in when a law seems to have been passed by time, or a law seems to be applied in a way that is retrogressive as opposed to progressive. For example, the affirmative action. Previously, we'd have women were counted together with the flock and the children, you know. But in this current situation, in this era, that cannot afford to happen. We have women now that can inherit
so
land.
There's a woman at her home, either ni ng'ombe.
Yeah, on our country as the children and the flock as their property, you know. So that is retrogressive because we have a modern day woman, a woman who's not necessarily under the cover of a husband. So what laws would she fall under? Would she need to be married off by force? Would she need to be inherited? Would she need to be bound by those different cultures? And even as we have intermarried, the cultural, I don't want to say that it has watered down, but there has to be something that will cut across all cultures. If I'm Masai, you're Meru, we get a child. That child might want to have his own, laws. And what laws would this be? It would be the law that we have agreed as a collective. So yes, the constitution and the social contract will govern or will supersede whatever cultural law is there.
Thank you for that educative piece. Now we come to Carol. Here comes a situation where our people find themselves in very many difficult circumstances to know where do I lie, or nimefanyiwa hiki. Where do I begin from? There is a case here. Someone borrowed you money out of a gentleman, unasemanga gentleman's agreement. I don't know now on your part, unasemanga aje? You'll tell us later. Then you gave this person 1 million shillings. Kumwambia ndio hiyo, alafu utarudisha at some point. Hiyo ni biashara yenu mmefanya pamoja. Then there's another case where someone comes and maybe robs. So wakati ana rob, utaona even minus informing the state that have been robbed, the security people will come and try to do intervention. But this other one, it is until you raise an alarm, alafu usongeshe huko mbele. Whether they even know that ndio ulipea Hadasa 1 million, then she didn't repay, the government may be aware. But unless you now tell them, they may not come in. What brings in the difference between these two issues?
Cornelius, I would say that I think what that question would ask, or rather what it means, is that you have two different laws. There is the civil law and there is the criminal law. So when you talk about the civil law, I would put it in the first practical question that you asked. If you borrow me money and I fail to pay you back, or what governs that? So that is that would be the civil law. That means if you injure the other person or you do wrong to another person, technically where you're supposed to pay some damages, or you're supposed to repay the other person, that would account to civil law. But when you talk about criminal law, these are laws which have been set by the state and which have some punitive consequences if you fail to follow the law. And more so, we say it's that you're wronging the state and not the person. So you might be having your property, and then I steal it. As much as it is your property, it doesn't qualify as civil law. However, it still qualify as civil law in one way or the other. There's something we call as we talk of conversion, but essentially that is criminal law. It is stated in the criminal, or rather in the penal code, whereby we have all these criminal acts, and if you look at any act which has been indicated by the state that this is a criminal act, there has to be consequences. What fine are you supposed to pay, or what sentence is imposed if such a wrong came to be. So if the law states that this is wrong, then the law should also tell you that these are the consequences of you failing to adhere to that rule. So if it is not there, if that punitive provision is not there, or the consequences of you doing wrong, or the sentencing, then that is not applicable. You cannot be sentenced by court, you cannot be fined, or rather whatever the court that's supposed to judge or delivers a judgment against you. But basically that's the difference between civil law and criminal law. And to add on to that, the criminal law, that's why you even say that it's the Republic versus Cornelius, Republic versus Hadassah. It is not Cornelius versus, Caroline, or Caroline versus Hadassah. Yes.
Thank you very much, Carol. Now I run back to Hadassah. You've given us very good foundation of the differences, so that from tomorrow our viewer can be able to tell that this is a civil case, this is a criminal case, and they can know where to run to or the approaches to make. Now, there is a case that is ongoing currently. I don't want to mention the person, but I'll just maybe use an example. I wake up, not me, let me use another example of someone else, because they say there's power in words.
Yes.
Someone probably harms or injures another person. And then after some time, they go around, alafu wanasema, we want to solve this matter out of court. And this person maybe hata amepoteza an organ of the body, and then the court probably allows this person to proceed, that ataenda agharamie matibabu, probably to settle the matter out of court. Is that thing applicable? Okay, is it legally?
Yes, the Constitution allows for alternative dispute resolution.
Yes.
Where you are allowed to, we are social human beings. If I have wronged you, and in as much as it is a wrong against the state, I have the liberty to approach you and say, yes, I wronged you, I am sorry, can we forgive this, can we settle this? And you will say, yes, I have forgiven you, and maybe you had stolen something from me, you will return it, and then we proceed as normal. But in as much as the law allows for alternative dispute resolution, there are certain offenses where we have taken upon ourselves to state that parties cannot go behind the tent. Tukutane nyuma ya tent. Parties cannot go behind the tent and agree. Cases, for example, like rape, defilement, even murder, because these are considered very grievous capital offenses. Okay, I should not have quoted, but they're capital offenses. They're very grievous offenses, which normally would attract very high punitive measures. And one of the reasons why we have those punitive measures is to prohibit a recurrence of the same, and also to deter, to prohibit, and to rehabilitate. So if at all I can, or someone, a perpetrator, can stab another, and then they go and approach the family and settle it out of court, what will stop someone else somewhere else from doing the same thing and going to approach the family. So those offenses which are considered very grievous and capital offenses, the law does not allow for alternative dispute resolution.
In as much as Hadassah, you've talked of the law not allowing such offenses to be solved out of court. Here comes a case. I won't again mention where, who, why, when, and how. But some guy murdered someone at some place. But this person who murdered the other one came from a very prominent, rich family. And then, just as you said, this person went somewhere, akalipa mandugu wa huyu na familia some money, and then the person is still free up to today. Do you think that part, Caroline, has been tightened to an extent of looking into those grievous mistakes, just as Hadassah has just mentioned?
As much as you're withdrawing a matter, and when we talk about reconciliation or even arbitration, when parties are given that opportunity to go and resolve their issues outside court, there are some principles that the court will also look at. And also, matters of public interest, how this is likely to influence, or even set precedents in the future. So when you talk about people trying to sort out, I'll give an example of what the case that you're talking about. And the aggrieved party would wish to withdraw this matter. It is not usually entirely to the aggrieved party. Remember, it is the prosecution which is usually in charge of the process of, or even the process of prosecuting an accused in court. So it is not, as much as you're the complainant, remember it is not you who have been wronged, it is the state. And that's why that's the distinction, that the state is the one that is in charge. So should you wish to withdraw the case, or even say that, oh, I have come, we have settled this, I have forgiven this person, you'll first, the prosecution will also need to understand whether it was either through whether you are under duress or perhaps coercion. Is it out of your own willingness? So it is the prosecution that will have the last say on whether they can advise the court or even accept that the case be withdrawn and not to proceed with the matter as against the accused.
Many thanks. We go for a quick commercial break. Tonight we are having here what we call a legal free clinic, where we have two advocates of the High Court of Kenya, that is Hadassah Rimunya and Caroline Nderitu, who are trying to help us bring out some of these contentious matters of the law that you keep on asking yourself every now and then without getting proper answers. But tonight we are getting it from the host's mouth. These are people who've studied law to the highest level, and they're currently practicing, and they're bringing it out for you to understand how to relate with others and even how to relate it with yourself. As we come back, we'll continue looking into some of these legal information that are necessary for you. Keep it on CAC TV.
Get wimenyerere dukareganirwo, dial star 811 star 187 hash and select 5. Health Nuggets features real people.
I'm a survivor of stroke. I was totally incapacitated.
Sasa kama hiyo nyumba yangu naona niliuza. Juu ya huyo mtoto nimpeleke Mathare.
Lazima ujikakamue, uone nani anaweza kukusaidia, umwambie ukweli yako.
Highlighting real issues on your health and well-being.
Especially for people who are pregnant, I'd advise them to keep off from that farm-bred fish from China.
Creates awareness on health matters affecting you.
We sometimes treat our cars better than we treat ourselves, right? Because every couple of miles you send it to the garage, right? You don't wait for it to break down. But with our bodies, you wait for the car to break down, as it were, then you say, okay, let me go to the hospital.
While good health is not something that you can buy, but be rest assured that health is wealth.
Don't miss Health Nuggets every Monday at 7:30 p.m. here on CAC TV. Your health matters.
The Bible should play the most important role in the life of a Christian regarding making decisions, major or minor. God gave humankind a freedom of choice between numerous possibilities, but the basic choice is between good and evil. Bibles are now available at the PCA head office bookshop, South C, Nairobi. We have Bibles available in English, Kiswahili, and Kikuyu. Make your purchase today. For more information, call 0722 205051.
Welcome back, and many thanks for tuning in to Powerbrief on CAC TV. And as I indicated earlier, we are having a free legal clinic that we are just trying to take you through some of the information that just from the experts that you're supposed to know on how to relate with others and how to relate even with yourself. And the temperatures in the room tonight are from Caroline and Hadassah is that there comes a time where the hunter becomes the hunted. These are the experts, but now we are actually moving head on. Now, before we went for a break, there are things that you actually tried to differentiate. You also did the same thing, and at least our viewers understand when it is a criminal case, when it is a civil case, what to approach, and also what to do. Now, there is also another important thing that has actually been giving people a lot of headache to understand, and these complaints are all over, concerning the criminal records, the clearance from the CID. And nowadays it's a requirement in the law that for you to meet Chapter 6 of the Constitution, you have to be cleared by the Credit Reference Bureau, you have to be cleared by the Higher Education Loans Board, you have to be cleared by the EACC, you have to be cleared by CID, and then also there's one that I've forgotten, KRA, that you are compliant to the law as it regards to those matters. Now, someone has been is being suspected of having committed a particular crime in this sense, and the law says that you're innocent until proven guilty. So in that process, everything goes on, and then it comes out that indeed this person is not a criminal. And then when they have been acquitted, this person, a big job comes, a big opportunity, maybe even with an international body or even with the government. Halafu anamka asubuhi anaenda kwa CID kuchukua clearance. Then this person realizes that even 2 years down the line after that case he or she was acquitted, bado kuna hiyo star ya kwamba hey, kuna criminal case here. And this outcry has been here and there that ile procedure of clearing your name after you've been acquitted. The courts have acquitted you, but now has the information gone to the CID who took you there so that they do away with it? I don't know, so far so good, the mechanisms that the legal fraternity has put in place just to ensure that this thing, mtu akishatolewa, tuseme ametolewa leo, probably after a week or even 2 days or even the same day, kuna hiyo kufuatilia that a decision on a particular case is being done today. Amekuwa acquitted ama amefungwa, and how does it go about?
Okay, so once you are accused of having committed an offense, definitely your fingerprints are taken. And that is usually the basis of getting a police clearance, the certificate of good conduct. So once that is done, your fingerprints remain in the database for perpetuity, which should not be the case. So you find someone years later after they've been acquitted, if the even if the IO in that particular matter or whoever was handling that particular matter leaves, they're the ones with the institutional knowledge. Years later, they have left. This gentleman or this lady has gone to pick the certificate of good conduct, and the person will go into the system, check what will come up with the fingerprints for that particular matter. So the sad reality is that we do not have legislation for what happens after one has been acquitted. How long should that follow them? How long should they remain as an accused, so to speak? So it is sad that that follows them, and we as a society, I think, we are trying to come up with ways to circumvent that, or rather solve that problem. I am aware there is a matter currently in court where they're trying to challenge the legality in itself of the certificate of good conduct, saying that it is infringing on the rights of a citizen. If at all, if I'm going to look for a job and something that I did way back that I was acquitted of still follows me, then I'm no longer innocent until proven guilty. So like you have said, it is sad. It's a sad state of affair, but we are hopeful that we will come up with good jurisprudence, and our legislators will come up with a law which will help citizens get their names cleared.
Let me just add to it, or rather just give some input to what Hadassah just said. In another way, you might find that this is also a positive, not a positive, but it also serves to protect the general public in essence. Now, let's give an example. Like in the US, if you're arrested and charged with a sexual offenses crime, if you're moving from one state to another, or you're moving your residence from one residence to another, you're supposed to notify the residents of that residence where you're moving that you have at one time been charged with such an offense. So there are these perpetual, criminals. You've done this, you repeat this. So it also serves to also protect the general public by perhaps telling them, you should be careful
while engaging
with
this individual.
I don't want to put it like you'd want to stereotype people, because even when people go to prison, it serves as a rehabilitation. People, change. They come out. They try to, put their business in order, and they have served their time. But on the other part, you'll find that there are people who are prone to commit the same kind or similar crimes over and over again. So if perhaps someone is a pedophile, someone who has also been arrested by molesting children, you should also be careful how you're dealing with such a person, assuming maybe you left your children in the care of such a person. So it serves to protect them.
So as that jurisprudence, which if I break down in language that someone else will understand, okay, that huo utaratibu in case unaenda kutolewa, it is in the pipeline. From your experience, Carol, handling legal matters, unataka kuona mtu anafaa kuwa amefanya tuseme makosa kama ya rape for instance, or makosa kama ya wizi, ikue intervals, amefanya kama mara ngapi kusema kwamba huyu naye star yake ifaa itolewe hata even after having been acquitted, anafaa awekewe hiyo something?
We do not, at the moment, we do not have any guidance on that. And that's why I hear my colleagues saying that we need legislation, or rather laws put in place to govern the question that, or rather to guide or to govern the relationship between us and maybe someone who has been convicted in the past. So it's not about how many crimes you have done or how many times you have been arrested. You know, the moment the society views you as a criminal, the moment you have been taken through the court process, or even the moment that you have served some jail time, people will start stereotyping you. You know, they'll call you a jailbird, you know, and someone, or rather the association with you changes from there henceforth. So it's not about how many crimes you have done, but it's very interesting and very queer, you know, when you talk about crimes which deal with integrity and chapter 6 of the Constitution. There's not really much stereotyping when it comes to that. Lakini niibie kuku, niibie socks, or my clothes from the hanging line, and I go through the system and I am put in jail, I serve some time, then I think it's at that moment that, you know, the society looks at you with this perception that you deserved, or rather you are that type of a person, or you're a criminal. You know, it doesn't matter whether you have served that time or whether you paid that fine. The fact is that you are sentenced for that particular crime.
Thank you, Carol. Now this leads us again to another challenging thing about what happens, especially in the legal corridors. This is the issue of witnesses. When we talk of witnesses, it could be you, it could be me, it could be another person. And in most instances, the head of state and a number of security agencies have been talking of, if you have any information concerning this, come over and then help us understand how did this thing come about, because we want to get justice. Today in the dailies, in one of the dailies which I think I forgot to come with it here, and it was also yesterday and another day, a case of a particular person who is said to have been lined up as a witness on a particular case which happened some time back, and it was continuing. That's just but an example, but there's so many others who've lost their lives, and when you go around you realize that this person was connected to a particular case. And even when you walk in the streets, you'll hear someone saying that being a witness should be counted as one of 1,000 ways to die in this country. So from where we sit, and even from where you sit, have you come up with jurisprudence that totally protects the witnesses, or there is that jurisprudence but there is that negligence to an extent that inajulikana kwa hii kesi ya Omuse, Carol ndiye amebeba evidence, she's a high witnesses, and then something comes in between?
Yes, we do have mechanisms. There is a witness protection program where high value witnesses, or witnesses that the prosecution feels are endangered because of the fact that they carry evidence that would put someone away, they are put in that program. Maybe the lacks is in the lacks is in the implementation of the program, but there is a program that witnesses are put in. I don't know whether that answers your question.
Now, it's still there, but let's also get from, because you're two different people. Okay, you're in the same line, but probably your experiences could be different as it regards to the witnesses protection. Maybe, Carol, from experience and from what you know about this thing, where has been the leakage to a point that, hey, atuin witness, ama alifaa kuwa witness, and then someone knows that, of course, when I was drinking that water, or when I was picking those bottles of water, it is so and so who saw me. And it is indeed true. Mi najua vizuri sana ya kwamba ile crime nilifanya na vile imesemekana huko, it is true. And maybe alinipiga picha. So by the time the evidence is presented in court, I'm fixed. Where has been this loophole?
I don't think Kenya has the resources when you talk about these witness protection programs. You know, if you need to register yourself in those witness protection programs, I know you can approach the court. I know there is one at the High Court in Milimani, whereby if you feel your life is threatened, or perhaps the nature of evidence that you'll be giving the court puts you at risk, of some threats with the other person, definitely you need some protection from the state. But the confidentiality in the manner this the program is usually executed, it is very wanting, because if sources are coming from everywhere, you know, the first person you approach, this matter has more so been publicized by the media, and even before you approach the witness protection program, everyone knows who you are, or that you're the number one, you know, prosecution witness number one. Then by the time you're going to the states, you're requesting for some assistance or some protection from the state to at least avoid these threats that are coming to you. But the resources, you know, it's the government now that's supposed to give you that protection. You're supposed to have police officers, you know, surrounding your compound, or even you're supposed to be taken to a private private site or somewhere where people do not know where you are, but we understand that you're being taken care of, and you're supposed to be produced during the date of the hearing to give that to give that evidence. But that is unlikely, because the resources that the government is also working with, or even those who are concerned, might be limited. So it's a challenge in its own way.
Let's come to reality briefly, Carol and Hadassah, concerning what you're just talking about, the witnesses, how they can be protected, probably an example of how their homes. Unajua hata ukisema unatunzwa every now and then, that can only be practical sometimes, maybe to the head of state only. But when it comes to the citizens, it becomes difficult. Now, when you look into this issue of witnesses, and at this time that we have technology, don't we think it is time we advance more with the technology to a point like, there's a time a CCTV was played somewhere, then unakuuliza, Hadassah, isn't it you? Then unaangalia, unaona it is you. But you can't know who took it. Rather than keeping on relying on this issue, mtu amesimama hapo kotini, mimi na suti yangu hapo hivyo, I'm giving testimonies to a point that after that you realize something doesn't go well. Don't you think that it is time we have this technology now being put in place to ensure that the more we move on, the more our witness is not easily known?
Cornelius, remember, even with the technology, there's something that we call corroboration when you're giving evidence. So as there are some instances whereby the court will ask you, you know, or you need to provide a witness who actually saw what was happening, because someone will come with the defense that perhaps that tape was doctored, you know, the quality of the machine that was producing that surveillance was not in good order. So the same thing applies. Number one, it's important that you have the technology now being applied and being welcomed, you know, as part of the evidence that is produced in court, which the court has so far adopted so far. However, you see that the resources, you know, it is also another challenge when it comes to that. And when you're talking about surveillances, what are we talking about? You're talking about you're guarding your home, you're putting CCTV cameras all everywhere to ensure that you're safe within your compound, or people do not, you know, we don't have trespassers within your home. If it's the government, you know, the roads are well taken care of. We know traffic is also manageable. But now, when you're presenting some of this evidence, as you're saying, we don't want to be solely relying on people. There are some instances whereby, you know, you go behind closed doors, the CCTV, you're told to turn off your phone, conversations which are taking place behind closed doors. So the only recourse that, or rather, the only witness who is there is the people who are in that particular room. So you cannot really do away with witnesses, me, you, and the other person presenting their evidence in court. But we won't say that we are rejecting the idea of having maybe the fact that technology is also something that can be accessed and also used to adduce these evidences.
Many thanks, Wakil Carol. Now we come to Hadassah and then to you. Hadassah, as you'll be giving your comment, it will also accompany with a parting shot, just probably an advice to people where can they get legal aid, legal information. There is this thing here where sometimes unasikia ati alipewa wakili wa serikali. This instance where probably mtu amefanyiwa maovu fulani, and most of the times huwa ina surround a person on defilement cases, sana ya land na ingine ni vigumu. Now, what qualifies an individual to access a government lawyer, and how practical is it? Because hata mimi pia ni most people wangekuwa wanakuwa na government lawyers every now and then, but seems this thing is not practical.
Okay. What you're referring to is pro bono services, which are not generally given by the government, or they're not government services. They are private practitioners who apply to offer pro bono services. And the Constitution guards or protects your right to a fair trial. And you'll find for capital offenses where the punishment was until recently death, they wanted you to have the benefit of the doubt and the best resources at your disposal, so that if at all you do get convicted, it was the trial was very fair, from representation, from giving evidence, from defense, everything was fair. But you'll find that most of these accused people cannot afford good representation, not just good representation, but any representation to speak of. So there is a program where advocates are advised to register as pro bono for their pro bono services. When such a person is in court and the court realizes that this is a person who is unrepresented, they allocate from their roster or from their register of registered pro bono practitioners. There are also other organizations that offer pro bono services. We have FIDA that really come through for women. We have Kituo cha Sheria, which really deal with refugee matters and person of interest. We have ICJ, which deal with a lot of public interest matters. So in as far as pro bono services are concerned, there are even private practitioners firms that have that arm where they say a certain percentage of our work will be pro bono as a form of CSR to the community. So if the public can inquire, I think they can get services.
Many thanks. And just as you wind up, is there hope, especially at the current dispensation, for anybody to access justice?
There is hope. We have seen the reduction of court cases, especially with the outgoing, the just retired Chief Justice. We have seen the backlog reduce, and we have seen personally in practice where matters are no longer taking too long in courts. So I think there is hope. The judiciary is working. We are working in partnership with them to ensure that justice is meted and justice is served without undue delay.
Many thanks. Let's also hear from Carol whether there is hope, and with the reforms that she has just spoken about, and where do you see Kenya in a few years from now on matters dispensation of justice, especially in the courts, because you're better placed to speak what happens in the courts.
I think when we had the guidance of Chief Justice Maraga, the first thing he did was to try and speed up the cases which were ongoing in court. So we've said that the wheels of justice, are slow, but when they operate, they really do their work. So it depends. It depends with how resilient you are during the process, because some of these matters, they need patience. You might find that you are not satisfied with the judgment or the ruling in the lower court. However, you'll say that you still have the recourse to appeal to the High Court or the Court of Appeal. So wherever, as an individual, all these forums are open to the individual to follow until a certain point when he feels that the law has served some justice. So I would say as much as we are working, and as much as the justice system is also trying to do its own work. It also needs the cooperation of the members, because some of the delays that you see in court or some of the disturbances or interferences that come with matters, it will also come from people who are trying to interfere with the justice system. So I think the justice system is there, and it's there to serve its purpose and to assist the kawaida mwananchi. So we should have some faith in that. If we will not have faith in that, I think we'll be taking matters into our own hands, and I don't think that will be good for anyone.
Many things. That is Carol Nderitu, an advocate of the High Court of Kenya, and Hadassa Rimunya, who is also an advocate of the High Court of Kenya. They have really taken us through this conversation, which has been so much educative and inspiring. And guess what? According to them, and according to what they were taught in campus, inside here, I'm the only man who is not learned. Though I've been asking them, they call themselves learned friends. We appreciate their contribution and the much they have contributed towards actually enlightening you to understand matters law. And as we've been having the discussion, we realize that we cannot conclude what we have because it keeps on growing and growing. And here on Powerbrief, we pledge that we will continue having this discussion because it helps us to promote our national mantra of peace, love, and unity in Kenya when you understand what concerns you. From me, Condolences, the entire Powerbrief production team, I really appreciate you for having stood with us since morning, from the coverage and all the discussions that we've had. Till next Thursday, God willing, have a very good night.